is Diane Miller from the National Health Freedom Coalition, and I'll be interviewing Jim Turner, the attorney on the California SB277 lawsuit today. I am the moderator for the U.S. Health Freedom Congress and the Director of Law and Public Policy for National Health Freedom Coalition. And Jim is the chairman of the Board of Citizens for Health, but he's also the lead counsel for the California lawsuit against the state of California regarding vaccines, a bill taking away the right of parents to decline vaccines or be threatened to not be able to go to school or daycares. Jim is leading a team of attorneys, and on that team is Robert Moxley from Cheyenne, Wyoming, Kimberly Mack Rosenberg from New York, and Carl Lewis of San Diego, California. So welcome, Jim. Are you there now?
Yes, I am. Thank you very much for this opportunity.
Oh, wonderful. It's good to hear your voice, and I know you've been working hard. We know now that the initial hearing request for a preliminary injunction was denied by Judge Sabsaw in the U.S. District Court, San Diego. So I guess the game is on now. Does this mean that you will be able to bring more of the vaccine risks and the human rights issues that our citizens are so concerned about before the court system?
That is our objective. We're working very hard to create a fact-based case about how to proceed to get to the judge's attention a lot of information that was not involved in the preliminary injunction hearing. It was very interesting when we had our first meeting with the judge before the hearing and before the matter started to unfold. He was under the impression that California was among 30 states that had no personal belief exemption.
Wow.
And when we explained the entire framework to him that there were only 2 states that had neither, besides California, that had neither a personal belief exemption or religious exemption, he was quite surprised, and I think his view somewhat moved. And now we had to make the argument in the preliminary injunction with the effort to keep the children in school while that battle that's now going to unfold took place. That argument was made strictly on legal grounds. There were no factual issues that were actually dealt with. We now are working hard to make sure that he gets the factual information necessary to actually understand what is going on with California. Our argument is that California is an outlier. It's done something no other state has ever done, which is repeal a personal belief exemption. One state, West Virginia, has never had such an exemption, and another state, Mississippi, in a very convoluted and generally recognized bad legal determination, eliminated that state's personal belief exemption. So we're saying to the judge, we want the judge to understand California is an outlier, and factually it's at odds with everyone else in the country, essentially, and here's why, and then lay out the fact, here's why that's important, here are the facts about safety and efficacy of vaccines. That's the direction that I would like to go with this case, and we're discussing all of those details internally with the legal team.
That's great. I noticed when I was reading the transcript from the hearing that the judge seemed very interested in whether there were any states that did not have religious belief exemptions. Can you comment on his interest in that? Because I think so many states have the religious freedom exemption.
He was trying to make that kind of an argument, and the fact is that as I said, there are only 2 other states that there's neither a personal belief exemption or a religious exemption. California had an explicit exemption from 1961 on. That's when they first mandated the polio vaccine. From 1961 on, they had a mandated polio vaccine and a personal belief exemption. And basically, as the law has unfolded since then, the states have been systematically moving in the direction, under the prodding of the courts and their own thinking, to broaden the religious exemption concept to make it be very close to a personal belief exemption.
Right.
So, for example, in an Arkansas case that Mr. Moxley in our group and I had roles in, 2 federal courts had declared the the religious belief exemption of Arkansas unconstitutional because it required that the person exercising that exemption had to belong to a religious organization that felt that vaccination was against their religious principles. And the court threw that out, saying that actually, essentially, they said that a legitimately held personal belief was enough to exercise the personal belief exemption. That was appealed by both sides for various reasons to the appeals court in that area. And while that appeal was pending, we worked with a number of folks in Arkansas, including the Arkansas Chiropractic Association, and they actually passed a personal belief exemption by legislation. That's the kind of dynamic that we think is in play here in California if we can actually organize properly to develop that position in the state of California.
Great.
Which, by the way, would mean core legislative action, which the judge talked about in his opinion.
Right.
I've said from the beginning of all of this that the ultimate resolution of this issue will be in the legislature. However, the courts will be the one that shape the directions that the legislature can go. They'll set the parameters for how the legislature can work. So our case is moving forward as a way of focusing and highlighting and creating access to the debate about vaccination. One of the major audiences for that is the legislature.
Right. Good. Well, I'm working hard with legislative efforts out in California, and I'm reading all of the hearing documents, the orders, all your memorandums, so that we can craft the proper legislation to bring back that freedom in California. So I'm very interested in watching everything you give us so that we can impact the legislation properly. Many of the organizations attending the U.S. Health Freedom Congress in August 2016 were concerned for the safety of citizens where the government can mandate a particular medical treatment and injections, and they can't sue the product manufacturers or doctors if they get harmed or die, and they can't opt out of government mandates. Will this lawsuit address that or work to protect informed consent?
My objective is to have that issue become a key part of the trial that goes forward, and we will have to first deal with the motion to dismiss, which will then become summary judgment. And in the course of all of that, we really want to create a record that puts into play all of that kind of information. I mean, the government has paid about $3 billion out to families who the government recognizes that the family's child has died or been maimed by a vaccine. The government recognizes that to the level of $3 billion having been paid to those families. There's about 4,500 families in the last 30 years. That's a very serious set of problems, and it only scratches the surface for all the people who have petitioned or all the people who didn't know about the petition program. That's a very, very serious red flag to the culture, and we want the judge to be aware of that, to understand that that's the context within which we're working. Off of that, we want to look at each of the 10 vaccines that are mandated and point out that each one of them has a record that raises serious efficacy or safety questions that undermine the notion that the state has the first of all the obligation, but even the legitimacy to require these vaccines for all children on a specific schedule, and if they don't, they can't go to school forever. They're banned from school forever. We would like the judge to understand that there are rational reasons why a parent might say, in my case, I think it's a better part of valor for me not to get this vaccination. So that's a key part of going forward in this case, and that'll start when what we expect to happen next, and what should happen next would be a motion to dismiss the entire case by the government, by the state. And either they will succeed, hopefully we'll defeat that, but if not, then that would be something that could also be appealed.
Well, that's great. I've been very interested in talking to many people about how to build their immune systems in different ways other than vaccines, and I'm glad that some of this factual information will go into the case. Do you think that there will be opportunities to show more detail about the evidence of how modern scientific research is finding new knowledge about the complexity of the immune system and overall health? and the potential negative impacts, as opposed to just
we are carving out that space. And I was intrigued by the judge's opinion. For example, many lawyers prior to this case being filed said there's no way you can win this case. Period. Can't be done. I got into the case about 10 days before it had to be filed because the case was, the previous lawyer stepped out of the case. But what we did was create a legitimate, solid argument, basically a complaint for moving forward on a purely legal basis. The fact framework was not there. It really wasn't right in the legal parlance. We moved forward, and the objective was to create a framework in which we could ultimately, during a trial, bring in all kinds of pieces of factual information. And this judge relied very heavily on an old case from the early 1900s. That case talks about various scientific issues, and I believe there are openings in the entire analysis of that case to bring in the kind of information that you are talking about, the development of science in the last over 100 years.
That case is so important, and I totally support that, going after that front on because of what was in there and because of the time in our culture. I know that the jurisprudence has changed over the last 100 years, and I'm counting on the fact that we can evolve legally into the human rights advocacy that we need in our culture. Do you think that the lawsuit will be able to, in those fact patterns, bring in any of the information about the top immunologists, vaccine scientists, and the CDC admitting that they suppressed the data showing the link between vaccine and brain injury?
We would like to be able to do that, and if we have strategies for creating a way for doing that, we have to develop that with some care. We need to understand, or at least, I want to just be clear, that we have objectives and we have the legal process, and we want to make sure we want to get this kind of information into the framework of the legal process. That requires a lot of care and skill and seeing what the state has to offer and so on, and responding to that and bringing in the kinds of things that we want to bring in to make sure that this stuff can actually be heard by the judge. I think as the judge hears these things, that he will at least be less confident about what the law requires. That's our objective. Make him less confident and more open to thinking about how to proceed with vaccine policy. At the same time, it is a fact that judges are constrained by the system to defer to legislators. And so in the final analysis, however far along we get, the law that the legislature passes is what will be in control of the vaccine world, and we need to influence that with this kind of information that we're discussing.
One last thought for me that I would like to just ask you about. I've always wondered, after reading the history of the vaccine in our country and around the world, quarantine seems to be a very important part of public health for many years, and hygiene and everything. And it's one thing to quarantine a citizen using due process. It's another thing to mandate that they get injected or treatments. And in Minnesota, when the bioterrorism bills started passing across the United States, we put in an amendment to the Minnesota law that said in case of martial law, we could always reserve the right to refuse any kind of medical treatment, experimentation, surgeries, vaccines, whatever they would require, but we would be okay with quarantine under due process in the least restrictive mode. Do you have thoughts about that?
The Jacobson's case point is that at that time the decision was made, there was what they were discussing was a situation where there was an actual smallpox outbreak, and they said that the lawmakers that passed the mandated vaccine regulation for all people, with children, with all people, had the authority to act in such an emergency, and it was not up to the court to decide which branch of science they would choose or which mechanism of action they would choose. The only thing that they would do was review the reasonableness of the approach, and would not allow an arbitrary and capricious intervention by the state. So there was a $5 fine that the person paid for not being vaccinated, and they said that whole structure was fine. That was totally within the power of the state. I think that the kind of emergency we're talking that there is a precondition for any kind of moving forward with a taking away the complete rights of an individual. And it is a fact that in the quarantine law framework, there are lots of places where this has been discussed. And in fact, there are laws that have been the focus of a lot of attention, such as the treatment of individuals in schools who are HIV positive. There's a lot of due process law that's been built there. And interestingly enough, so far, none of it has extended into the vaccine area. So there's like a funny anomaly in the California law. There's one disease which the law says if hepatitis, if you have it, you can go to school. But if you're not vaccinated, then you are not allowed to go to school. So that the healthy person is kept out of school, but the ill person is allowed in school. These are the kind of anomalies that have not been looked at by any decision-making body with care, and we want to do that with this judge, hopefully.
That's wonderful. We are behind you all the way. Thank you so much for your work, Jim, and your whole legal team and all the people behind you in the outlying states that are supporting you.
Yeah, one thing, Diane, you might point out that the Health Freedom Congress, what did you have, about 30 groups there?
Yeah,
and they actually agreed that the SB277 project and rolling back the repeal of the personal belief exemptions was the number one thing they all agreed on.
That's right. We actually all supported the fact that that was a top priority in the country right now, and we're all going to be supporting it by collaborating on alerts. There was, I believe there was 30 some organizations, I have the list here close by, but I don't have it right here, that have endorsed the concept of going forward and supporting the vaccine repeal in California. We think it is, as the discussions unfolded at the United States Health Freedom Congress, we believe that it's when a government can force or coerce its citizens into injecting something into their bodies, it doesn't matter what it is, that we are in trouble as a country itself. Like our country can't withstand, the people can't maintain their freedom if government has that much dominant power. We're seeing that this is not just a health issue, it is the stability of our free society, of our republic government, and we need to reverse it and put into balance somehow a better balance with the government control of our lives.
I would say I'm into that. That's what we're on to here, and that's where we want to go.
Okay. Well, thank you so much, Jim. And
thank you, Diane. I really appreciate the opportunity to talk with you.
Alrighty. Take care. Bye-bye.
Thanks. Bye.